Emma Mijas died a horrible and painful death unnecessarily on her very first Christmas Eve 2004 at the hands of 25 doctors and nurses, another victim of medical malpractice. All 25 doctors and nurses systematically administered the wrong drugs for her life-threatening condition called SLOS. SLOS, Smith-Lemli-Optis syndrome, is a congenital abnormality which requires treatment strategies on supplying supplemental cholesterol. They gave Emma the wrong drug, Questran, not once, but 92 times. Yes, 92 times in 1 month. A cholesterol-reducing drug, not the cholesterol supplemental drug she needed. All of them knew better. They were trained to know better. They were some of the world's leading authorities at the Louisiana State University Health Science Center in New Orleans. But they just didn't give a damn about Emma's life. In 2013, the prestigious Journal of Patient Safety published a study that as many as 440,000 patients die each year from preventable medical errors. That would make medical errors the third leading cause of death in America, behind heart disease and cancer, which is second. These people are not dying from the illnesses that caused them to seek hospital care in the first place. No, they are dying from mistakes that hospitals could have prevented. What are these fatal errors? Who are these incompetent and negligent doctors? A New England Journal of Medicine, January 28, 2016 study reported that 1% of physicians accounted for 32% of paid malpractice claims over the last 10 years. The ugly truth is that little is being done to hold these dangerous doctors accountable. Researchers found that bad doctors showed distinctive characteristics, including having paid previous malpractice claims. So it stands to reason that healthcare providers could eliminate 1/3 of medical malpractice along with patients' pain and suffering, as well as the added cost of corrective surgeries, long-term care, and indemnity payments by removing the worst 1% of doctors. Why aren't bad doctors stopped from practicing? The answer lies, at least partially, in the National Practitioner Data Bank, a clearinghouse for information on medical malpractice that Congress established in 1986 to help state licensing boards police the healthcare industry. The national database was supposed to help states identify dangerous doctors and prevent them from harming more patients, and is used by hospitals, insurers, and licensing boards to track doctors' records, check prospective hires, and make other decisions. But it is virtually useless in holding doctors accountable because, by federal law, none are listed by name. They are assigned a random number to protect their identities. Even if doctors were identified in the data as they should be, the public would still be barred by law from accessing the records. So vulnerable, sick patients sit in the waiting rooms of bad physicians without a clue about their poor record of performance. And in many cases, a negligent doctor's insurance company pays the victim of malpractice and the doctor goes back to work. If a doctor develops a bad enough reputation in one town, he can move to a new state and continue practicing. This is unbelievable. But today, the public does not have access to the database to identify doctors' names and addresses, to identify doctors with uniquely long histories of being sued or disciplined for medical malpractice. Because on September 1st, 2011, the government cut off public access. What was behind that decision? Apparently, one Kansas doctor with a trail of malpractice suits, Dr. Robert Tenney. The Kansas-based doctor complained to the Government Health Resources and Service Administration that the Kansas City Star newspaper was publishing the story of one of his patients, Mary Beth Chase, who died in 2007 after undergoing a brain surgery with Dr. Tenney. It is also noted that Tenney had been sued at least 16 times for medical malpractice, but had never been disciplined by the state's licensing boards. The Insider Exclusive produced a TV story on this case with the lawyers who represented Mary Beth's family when doctors go bad, Mary Beth Chase versus Dr. Robert T. Tenney. Tenney finally settled the Chase family's wrongful death suit for $1 million. The settlement brought total malpractice payments paid on Tenney's behalf since the early 1990s to roughly $3.7 million. In some states, including California, Colorado, Georgia, and New York, patients can go to medical boards' websites to find out about doctors' malpractice histories, but not in Kansas and Missouri. Why don't doctors report on bad doctors? Physicians often see the mistakes made by their peers, which puts them in a sticky ethical situation. Should they tell the patient about a mistake made by a different doctor? Too often they don't. Why not? One reason is that doctors depend on each other for business. So a physician who breaks the code of silence may become known as an informer or snitch and lose referrals, a financial penalty. Doctors also may be wary of becoming entangled in a medical malpractice case or causing a colleague to face legal consequences. The bottom line, too often doctors aren't learning from errors, nor are patients getting the information they need to receive proper treatment or compensation when the outcome is harmful. In this Insider Exclusive Network TV special, America's Medical Malpractice Crisis, What You Need to Know, we visit with Aubri Sheremet and Stephanie Hoffer at the Hoffer Sheremet Law Firm as we take you inside today's legal system, examining lawyers' strategies and clients' thoughts, and in vivid detail showing you the often heartbreaking stories of these clients, dramatically demonstrating what motivates Aubri and Stephanie to fight for their clients' causes. Here's just a few of the stories of many victims of medical malpractice that the Insider Exclusive Network TV shows have featured on Network TV.
When the doctors gave me the choice and the options on the table, either to save her life or to let her pass and peacefully without no pain, it was a small chance that she might live after surgery. But I chose life because I think that anybody deserves a fighting chance. So I decided, my wife and I decided to go ahead with the surgery and give her the chance to fight herself. My daughter Malia is special because she has a positive outlook on life in general, on how well she can accomplish things, how she's not different in any other way from anybody else besides the fact that her legs are metal. When I realized that this could have been possibly avoided by doctors seeing my daughter sooner, of course I was very angry. But I was also focusing on my daughter's condition at the present time. But it also made me think a lot about myself if I would have, demanded her to get attention sooner. I mean, there shouldn't be these things where we have to look back on it now and say, I wish I could have done this different. I wish I would have done this. Well, my daughter doesn't get that choice anymore. She has to live with this for the rest of her life. So hopefully this would be a learning experience for the doctors. That's why I would forgive them and tell them that they may just get better at what you do or pay more attention.
She was a tremendous life, unbelievable energy. She threw parties and she had people over, and she always made dinners for anybody who was sick, and she got involved in every campfire girl, Boy Scout.
She was very capable, smart, giving, dedicated to her children, dedicated to me.
And I kept saying, Mom, what's wrong? What hurts? And she says, my abdomen. And she was miserable. And we said, well, please call a doctor. She needs to be examined. We asked him 3 times.
The nurse said they'd call the doctors. The doctors were aware of the problem, but the unfortunate part about it is the doctors never showed up.
And that's when I reached down and hugged her and I said, "We're here." And she opened her eyes.
When the doctors told me that I had to make a decision for my husband's amputations to survive or just let him go, that was very difficult for me. I had to think about it and pray about it and talk with my family. It was a hard decision and life-changing.
My wife has been an angel. She's stuck by me. She's done everything for me. My mom, my sisters, my brothers, my kids. Without them, I wouldn't have made it.
Dr. William J. Irwin failed to comply with the appropriate standard of care for an OB/GYN in the year 2007. And as a result, Rebecca Gatti, a newborn baby, suffered severe brain damage which is lifelong and irreversible. Those brutally frank words were how the Louisiana Medical Review Board explained to Ryan and Susan Gatti, the parents of their new baby girl Rebecca, why Rebecca had suffered irreversible brain damage due to the incompetence of Dr. Irwin, and now will require round-the-clock care for the rest of her life with no chance whatsoever for improvement.
Well, on the day that I gave birth to the boys, I was very scared. You know, it's first time you're getting all ready to, your life to change. In the delivery room, they would monitor me and they had all this equipment on me, and then all of a sudden, when he pushed down on my stomach, when the placenta blew away from the uterus, I let out this really loud scream, and it was very painful. And then I just looked at my sister and I knew something was really wrong. I first realized something was wrong with Hunter. Well, he was in the NICU for a week, 8 days. And when he got released, they had told me that Hunter was going to have learning disabilities and he might be dyslexic, but they never mentioned that he may have cerebral palsy. If I had a chance to talk to the doctor today or directly to him, I would say, how dare you? How dare you take away the life that I was supposed to have? And how dare you do this to Joshua?
What I miss most about my mom are the holidays. The house was transformed. My biggest challenge with my mom gone is trying to step in her footsteps. Doctors who are not qualified to perform certain procedures, their license should be revoked. Dr. Jacobowitz, I don't have words. I don't have the words to express what your actions has done, the pain and the suffering that it has caused that can never be reversed.
These are just a few of the real medical malpractice victims who have dealt with our legal system victimized by bad doctors. This is why we all need to protect a legal system that is designed to protect us, and not one that protects incompetent and negligent doctors, nurses, hospitals, and their insurance companies over the common everyday American. Aubri and Stephanie, our featured lawyers, have earned the highest respect from citizens and lawyers alike as some of the best trial lawyers in Grand Rapids and Michigan. They have seen many innocent and hardworking people injured and die as a result caused by negligent and incompetent doctors, hospitals, and nurses. Their passion is problem solving. They approach each case as scientists trying to solve a puzzle. They've seen many patients suffer needless injury, and because of that, they are driven to help people who have been harmed by incompetent and negligent doctors. Their goals: to get justice and fairness for injured people, safeguard victims' rights, and to help guide the hands of justice. This is the Insider Exclusive, live from Grand Rapids, Michigan. It is my great pleasure to introduce Aubri Sheremet and Stephanie Hoffer to the show. Welcome to the show.
Thank you. Thank you for having us.
Aubri, tell our audience a little bit about your law firm. What type of practice do you guys practice?
Well, at Hoffer Sheremet, we do mainly medical malpractice. So that can include wrongful death cases, surgical errors, birth trauma, misdiagnosis. We also do legal malpractice as well, but mainly we're a medical malpractice firm.
And Stephanie, before the show we were talking, you guys have been really busy, haven't you?
We have been.
Even during the pandemic, right?
Yes, we expected more of a slowdown than we had. We were affected by not traveling anymore, so we were doing depositions remotely, but that also has given us an opportunity to increase our caseload because we are doing so much more remotely. It really has saved a lot of time.
Right. Now, both of you were at a defense firm before where you represented, I like to say, the bad guys, right? You represented the medical profession, right? And corporations. But both of you had an epiphany and you decided that you wanted to represent the little guy. Aubri, why did you make that decision?
I think for me, I started my career as a prosecutor, and so I really enjoyed helping people and seeing an actual result and really getting to know someone. And I think with our firm and what we do now, we get to know our clients over the course of years. I mean, a medical malpractice case takes 2 years or more to resolve, and we're working closely with our clients sometimes day in and day out, and we get a result for them, and we see that change, and we see helping them. I think for me that's been really powerful.
And you know, when we were defense attorneys, we tried to do good from the inside, from speaking at hospitals, from representing doctors, but also counseling them. And every time I would look at the plaintiff's side, I saw a hugely underrepresented population. So for me, making that switch was just really providing an opportunity for individuals to pursue medical malpractice claims that otherwise would not be able to.
When you say a hugely unrepresented group, why is that the fact?
In Michigan, we have very few medical malpractice lawyers, and particularly our home base of Grand Rapids, Michigan. And most of the medical malpractice lawyers that there are, they're older. They started their practices before tort reform, and after tort reform, there were just much fewer attorneys entering into the field.
So Stephanie, you mentioned that the word tort reform for our audience. What does that mean? And why aren't more trial lawyers representing the victims of medical malpractice?
So tort reform came about beginning in the 1970s and 1980s as a response to what was considered an insurance crisis. It was only an insurance crisis because doctors were paying premiums that were higher than they wanted to pay. So in the collective wisdom of healthcare and the insurance industry, they decided that the way to lower healthcare costs and lower insurance premiums was to put a series of measures in place that would make it more difficult for patients to sue, that would limit the amount of damages that they could recover in the event there was negligence. And unfortunately, it became apparent very early on that tort reform was not going to lower healthcare costs. And the measure stuck around anyway.
Yeah, what I've discovered is after, and the right word to use here is caps. In other words, you can't get more money in two types of damages. One is non-economic, pain and suffering, and the other one is economic. There's a limit, there's a ceiling.
In Michigan, we do not have caps on economic damages, just non-economic damages.
In California, and I'm sure this is the case everywhere, the insurance companies promised the doctors that if we had these caps, then their insurance premiums would decrease. Did that happen?
Because think of it like this. If you are making more money, when have you ever seen a business lower prices and pass those savings on?
One of the problems with a limit on the damages is that doctors get basically a pass on being incompetent and negligent, right?
They do. And that's twofold. One, because their exposure isn't very high. And when you think of, when you look at the number of doctors that are actually sued for malpractice, it's very few, but you have a lot of repeat offenders. The other thing is the economic benefit to a patient in Michigan. Even with, not having a cap on economic damages, they receive very little. And going through litigation is traumatic for anyone. It's very stressful. It's time consuming. But at the end of the day, after liens are reimbursed, after the cap is applied, there are many patients that are severely injured, but because their economic outlook, maybe they weren't working before, maybe they were already on disability, because they don't have those economic damages outside of medical expenses, all of which get repaid to the insurance company, it's just not a worthwhile benefit. So all of those surgeons, all those doctors, they get off the hook when they harm really our most vulnerable populations.
Yeah. We're going to talk about prosecuting some of these cases, and you need experts and the problem to get experts. But I want to ask you, Aubri, for our audience, what is the definition of medical malpractice? And when I ask that question, there's a lot of people who claim that the doctor did them wrong, screwed up. But, doctors are human. They try their best. Sometimes they make mistakes. Sometimes it's not a mistake of the doctor. The patient just dies. How do you define medical malpractice?
Well, and I think that's a good point. A bad outcome does not necessarily mean that there was negligence. So in Michigan, we have to define the standard of care for that particular specialty. We need to have expert support, identify what the standard of care says, for example, the surgeon should have done. Did they breach that standard of care? And what should they have done differently to comply with the standard of care? We also need to show an injury, which most people who call our office, that's the first thing that they talk about is their injury. But there has to be a causal connection between the injury and the violation of the standard of care.
In any trial, you're going to have to get experts when we're talking about proving, did it meet the standard of reasonable care? You're going to get experts that are going to say it didn't. The other side is going to get experts that say it did. So now it becomes a battle of experts. So let's talk about, getting experts, because we all know the movie The Verdict with Paul Newman and trying to get the right kind of expert. There's a lot of doctors who won't testify in their local community. And what I've found is that, for example, the insurance companies, again, are behind the scenes pulling the strings, because they'll say to the hospital, did you know that Dr. So-and-so is going to testify against your other doctor? And that means that if we lose the case, your insurance premiums for the hospital is going to go up. Right? Do you find that to be the case?
We certainly find that doctors do not want to testify against other doctors, even in the same state. A lot of times we'll have a client say, well, I went to another treater and they told me that my first doctor committed negligence. And And that should be something, right? They'll come to trial and testify. And we often have to tell them, they may tell you that behind the scenes, that's never going to be in your medical record, and they are not going to come to trial and testify. So experts on the plaintiff side, for any plaintiff's firm really, you have to look outside the state. Because we do find many experts talk about how important it is for them to support cases on plaintiff and defense side. You know, if you get a really good expert and they are looking at the case objectively, they are looking at, did that physician violate the standard of care? But it is for sure something that you have to look out of state for.
A lot of lay people don't realize that, you know, you have a business and you have to operate it profitably, so you have to take on good cases. Experts cost a lot of money, and since you are a plaintiff's firm, you only get paid if you win, correct?
Correct. And we also advance costs of litigation.
That's what I was going to bring up. Some of these experts I've seen, from the date you engage them to the date that they go to trial, might cost $25,000 to $50,000 each. That's a lot of money.
It is a lot of money. We tell our clients, on average, you know, it costs about $40,000 to get a case in shape to talk settlement, and another $40,000 to get through trial. That is the average case where you're suing one doctor or there's only one specialty involved. If you have miscommunication cases where you have a hospitalist and a surgeon and a nurse and none of them were talking, so all three are to blame, the costs of that litigation are astronomical.
Obviously, in many of these cases, you know, doctors have their own practice outside a hospital. They have hospital privileges. In many of these cases, the hospital is named as a defendant too, correct?
Right, and at least in our area, we see more and more hospitals are kind of eating up small practices. So sometimes you get doctors who have their own practice. A lot of times they're also connected with the hospital.
So I'll ask you this question. How do these caps hurt the injured parties?
Well, one, when I have to look into the face of parents and tell them that no matter how much they are grieving because their child has died and that child suffered, the most they can see is $476,600. That is heartbreaking. It's bad news to deliver. It is very difficult for them to hear because that is the value that we have placed on human life. But also from a practical standpoint, you have to, you know, from this pot of money, all of the medical care that that child received, the health insurance company gets reimbursed for. All of the expert witness fees come out of that award. Our fee, because we need, like you said, we have to run a profitable business. At the end of the day, those parents, you know, they lost their child, they have gone through the hell of litigation, then they have to sign a settlement that is almost always confidential, saying they will never talk about what happened, they will never say that anyone did anything wrong, they'll never share how much money they got, nothing. All at the end of the day for what boils down to, you know, a couple $100,000. Let
me bring that up. These cases are in the public domain. You go to trial, the doctor's name, the hospital's name. Of course, if you sign a settlement, the injured party can't talk about it, but how can an outsider get access to this information, and what happened?
So very few cases actually go to trial. Most cases settle before trial, at least where we practice. But if a person would like to learn information, it's very difficult. So court files are open to the public, but in Michigan, very few of our trial courts are actually on electronic filing or electronic records. So you could call the clerk's office and give them a doctor's name, and they can return to you a list of cases if that doctor's been sued. Other than that, you can look on the licensing board to see if there's been licensing action.
Now, in the state of Michigan, can you put in a doctor's name and find out if he's had other lawsuits against him?
No, not on a centralized government website. You would have to go to each particular court.
There's lots of courts.
There are lots of courts.
I mean, it's going to take you forever.
Yes, and with many of our counties not being even on electronic records, you would have to actually either, like I said, call the clerk's office or go in person to each county. And Michigan's a pretty big state.
You mentioned earlier that, and I think the figure is either 1 or 3% of all licensed doctors commit about 30% of all the medical malpractice cases. Okay, that's an interesting statistic, but one step beyond that is a lot of those doctors are still practicing, aren't they? So the question I want to ask you, Aubri, is, you know, doctors sued, they settle many cases, a lot of them are confidential, right? But he's still got his license. He's still butchering people. He's still negligent. He's still incompetent. Why doesn't the medical profession police their doctors more carefully so they'd eliminate the problem?
I think they circle the wagons. They do the exact opposite. I mean, and we have a client now who was injured by a doctor who has been sued multiple times, something which she didn't find out until after she started looking for an attorney, and she was shocked. I think the average person would be shocked to know that there are doctors practicing now that have been sued multiple times and either go to different hospitals, go to different cities, and just keep practicing.
Yeah, my understanding, as I mentioned the case that we recently did in Honolulu, the hospital has a responsibility, and they have access to better information than the common everyday layperson. So they are named as a defendant because they didn't do their job either, did they?
That's correct, and those are negligent credentialing claims usually, and those in Michigan are also can be very, very difficult to prove because a lot of the information that the hospital gathers has been determined that in a lawsuit we just simply can't get.
You can't get it even in trial, and you request it in your discovery.
Correct.
That's crazy. You know, why can't you get it? They say it's patient confidentiality.
It's actually, the hospitals, have a privilege. It's a peer review and credentialing privilege where we are not allowed to have any information that they use to credential a physician, to give a physician privileges. And also, when they are investigating a physician or any healthcare provider, we are not allowed to see that information. So if a hospital does an internal investigation after a patient is injured, we're never allowed to see that information.
Wow. Is that just in the state of Michigan?
I think that there are peer review statutes in almost every state, but Michigan's is particularly...
That stacks the deck against you guys.
Yes.
Is there any kind of legislation on behalf of plaintiff lawyers that is trying to change that in Michigan? It should be changed.
It should be.
Because it makes it unfair.
And it allows for a doctor who really shouldn't be practicing to keep practicing.
We have a surgeon that we're getting ready to sue now who's been sued 14 times. This is going to be lawsuit number 15. And, you know, people can say all day long, well, just being sued doesn't mean that you're a bad doctor, doesn't mean you're negligent. And okay, that could be true, but 14 times, it's a lot of times to be sued. The best way to limit lawsuits and medical malpractice claims, but also medical malpractice itself from happening, is to let the public know the surgeons that have been sued, how many times they have settled cases, how many times a jury has said that they committed negligence, and give patients a choice, let patients make an informed decision.
Right, and when you really think about it, I mean, I've often thought, okay, when you bring your car in to get it fixed, you're going to go on Yelp, for example, you're going to check and see the ratings of this guy's a crook or whatever, right? We're talking about doctors who cut you open, you know, put a knife in you. And if they're negligent or incompetent, you can die or you can be permanently injured and you can't get information on them. That is absolutely amazing. Let me ask you, both of you, you've deposed doctors before, and obviously, what have you found their attitude is when you're deposing them about something that they were clearly negligent about? What's their attitude? Do they have like the God complex? I did my best. Why are you questioning me?
I think it really, we have seen just the whole spectrum. We've had doctors cry oftentimes we bring our clients to the deposition because they're a party, and I think that makes a big impact, and that we've had doctors cry during their depositions.
Does their lawyer tell them to stop crying? I'm just curious. No, seriously, because, they don't want them to express any kind of remorse, right?
And we do have doctors who come in very defensive off the bat. And a lot of times in those cases, they will deny things that are very simple, right? You say the sky's blue, and they'll say, no, it's green, so they go almost too far the other way in denying even the things that common sense would say otherwise.
Do you use your depositions in trial?
Well, only for impeachment, but we've had trials where their depositions and their denials have come in very handy, because again, it's a jury. You have people looking at it from a common sense perspective, and they're sitting there, you can see the juror's face saying like, well, come on, that doesn't really make sense.
My favorite moment in trial, I think, ever was when I was cross-examining the defendant doctor, and he kept just making so many statements that were inconsistent with his deposition. And we have a very specific procedure we have to follow in Michigan to impeach a doctor. So finally, after maybe the 10th question, I held up his deposition transcript, and I held up my outline, and I said, on here, I have every single question I'm going to ask you, and I have the answer in your deposition. And every single time you say an inconsistent answer, I'm going to go to your deposition and read it as I have been. So would you like to start telling the truth?
Yeah, let's talk about, we mentioned there's, some people who think their loved one, died as a result of incompetence or negligence in a hospital by a doctor. What do you find most people immediately do after that? Do they contact you guys, like law firm, or can they get medical records, and do you recommend that they try to get medical records, and is it difficult for a layperson to get their medical records?
So as far as how long until someone calls us, some people know right away that something very bad happened, and they call pretty quickly. For other people, they are we find this especially when the loved one is severely injured. A lawsuit is not the first thing on their mind. The first thing on their mind is adjusting to their new normal and getting the help that their loved one needs. And when those people call us, it's usually because they always felt that something wasn't right, but the reason they usually call us is because they have medical bills they can't pay, their spouse can no longer work, and they can't pay their mortgage, and they need the system to work for them so that they can receive compensation so that their lives aren't completely destroyed financially. The medical records issue, it is not easy to get medical records.
For the layperson or for the lawyer?
Both. Okay. So we have the Michigan Medical Records Access Act that indicates that patients are entitled to a copy of their medical record.
Within what period of time?
Usually 30 days. The problem is when they submit the request, they will not get a complete set of medical records. We will not get a complete set of medical records.
When you say not a complete set, what is left out?
It varies. Most of the medical record requests are now outsourced to one of two companies. And those companies are, the requests are fulfilled by lay people, and they pick and choose what they include. So sometimes we're missing imaging, sometimes we're missing nursing notes, sometimes we're missing lab results. It takes us usually 3 requests to actually get all of the records.
When you say they pick and choose, is that because these outsourcing companies are lazy, or because they've been told not to include everything?
I don't think they've been told. I think that would require, too much of a coordinated effort. I think the way the electronic record systems work, they have to pick and choose what boxes to print. You know, it's not like it's a paper record that has been scanned in, so it's not really amenable to printing. And I think they don't get paid very well. I don't think they're familiar with what is in a medical record because they're not clinical. And I think there's a aspect of laziness to it.
As a layperson, Aubri, do you find or you recommend that relatives of patients who might have been harmed by a doctor, do you recommend that they file a complaint with the hospital? And is it a waste of time?
I think it's so very case specific, but I don't think that there would be anything negative to do that, because every hospital has patient relations or risk management. I think that in cases, especially if there's a case where there isn't necessarily negligence, but the family just wants more answers, I think they can certainly do that. They can also request the legal medical record, and just going through and reviewing that might help them as well.
After all of your cases, when you have, like you mentioned, you have one doctor, you're suing him for the 15th time, do you, when you settle a case, are you allowed, and against the doctor because he screwed up, right? Are you allowed to report him to the regulators? Who does that? How do you alert the review boards of the state that, hey, you got a wild card here that maybe you ought to check into? Are you allowed to do that, and do you do it?
In Michigan, we have LARA. It's the Licensing and Regulatory Affairs. We often tell patients, especially if it's a case that is just not going to be worthwhile financially for them to pursue, we often tell them to make a complaint. A patient can do that online themselves.
But the lawyer can't or doesn't?
The lawyer can, but it's certainly, we always think it's better coming from the patient. Anyway, they have more of the information, especially at that point. So often they make a complaint online, and then LARA will investigate. They're required to investigate whether or not they actually, how thorough or what the outcome is. We're not typically involved in, but we have seen situations where it's been surprising that they haven't continued their investigation or found findings.
What I have found, the most egregious, incompetent doctors, sometimes the licensing boards, rather than suspending or revoking their medical license, I've found that they bring the doctor in, or maybe, transmission of correspondence, and say, it might be better for you to surrender your license. That way you can move on to another jurisdiction. And when they ask the question, have you ever been disciplined by any medical review board, you can honestly answer no. And I find that happening in the medical profession time and time again. And doctors move from one state to another and just continue to maim and injure and kill patients. It's really a shame, because the medical oath said that you have to protect the patient, and some of these doctors don't do that. Let me ask both of you. There are a lot of law firms that profess that they can represent a client in medical malpractice cases. What makes your firm different from them?
Well, several things. One, we're not dabblers. A lot of attorneys are taking on medical malpractice cases, and they don't actually practice medical malpractice. They think it's a quick way, to make a lot more money than you would if you pursue a car accident case. But when you are a medical malpractice lawyer, you have got to become an expert in the medicine as well as in the law. So medical malpractice is pretty much exclusively what we do.
You have, being a medical malpractice specialty firm, you have a lot of people contact you and your law firm to help them out. How do you eventually decide which cases to take?
Again, I think we do that with a team approach. Stephanie and I, we like to talk to every potential client before we make any final decisions, but we like to know when clients call what their injury was, when it occurred, who the physician was. We usually do a lot of our own medical research. We do the legal research. And then before we make any final decisions, we look at what the potential financial outcome would be for the client, because litigation is really tough. And if it is a situation where there are not a lot of economic damages and the non-economic damages are capped, and that money is going to be eaten away by costs or lien or other out-of-pocket expenses, those are cases that we have a real frank conversation with our clients about whether or not it is really in their best interest to pursue.
Right, and you had brought this up before about, you have to pay the liens. You're able to negotiate oftentimes with some of the organizations that have liens and reduce those costs, are you not?
It is rare now. It used to be that we were able to do that much more than we are now. If it is a Medicare lien, it's non-negotiable, and they won't even cover the attorney fee portion of that. Some of the private insurance companies, the lien is still non-negotiable, but they will at least cover the attorney fee on that recovery, which is only fair.
Well, I want to thank you for both being on the show. You're doing a great job, and we hope to see you again soon. Thank you.
Thank you. Thank you for having us.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.